so let's go ahead and get started.
Do it.
On this side of the table is the United Faculty of Florida bargaining team. And I'm gonna go ahead and let them go down the table and we'll introduce ourselves. Start with you.
Gregory McComb from the Department of Mathematics, Chapter Secretary.
Richard Manning from the Department of Philosophy. I am the co-chair of the bargaining committee and also secretary of the Faculty Senate.
I'm Ed Mitchell. I'm your chief negotiator and I co-chair with Richard. And I'm a double alum of the University of South Florida and a lifetime member of the Alumni Society, which got me free parking today.
I'm Susan Ariev. I work at USF Libraries in the Research Instruction Division.
Steve Pernier, College of Education.
Arthur Shapiro, College of Education.
Sonia Ramirez Lorman, and in world languages, and I'm also the chair of this chapter. Ariana Moa, I'm the department, and I am the vice president of the chapter.
Kenny Mancucci, School of Geosciences.
Timothy Boaz, Professor Emeritus, College of Behavioral and Community Sciences.
All right, well, we'll introduce ourselves. Faculty to start.
Sure. Michael Farrell, Human Resources.
I'm Gerard Solis, General Counsel.
I'm Mike Banamore.
I'm Steve Tauber. I'm a professor of political science. I'm the vice provost for faculty and history.
Rick Dawson, Senior Associate General Counsel. Chris Garvin, Professor and Dean of College of Math.
How you doing, Matt?
We're doing well.
Good.
And you guys?
Good.
Everybody?
Good.
All right. It's nice to see so many people we already know. We've come today with two proposals. The first one is a proposal to status quo Articles 1 through 5. I believe that we have massaged these 5 articles so many times since 2003. And before that, a lot of this is imported Blue Book language. So there are no changes from the last contract.
Okay, does anybody have any questions about these 5 articles? Well, we'll take a call for saying.
Yeah.
Anything else?
We do, but the next one's going to be a little longer discussion. So if you want to caucus, you
I don't know
know.
if you guys want to take a caucus, you want to go right to the next.
I think go the next one.
I think we can go next.
Okay.
And you might want to caucus about that too.
The next one, a topic that seems to be on everybody's lips right now. Richard, if you would.
Sure. I've prepared some introductory remarks. So artificial intelligence, especially in its new generative forms such as ChatGPT, is already revolutionizing several aspects of higher education landscape and is developing at lightning speed. The technology is both promising and threatening, and avoiding the threats is at least as important as taking advantage of the promise. Among the promises are that generative artificial intelligence, or GAI, can save faculty from the burden of tedious and unrewarding grunt work that can be done just as well or better and more quickly by GAI, with no loss of value to faculty, students, or to the quality of resulting education experience, research, and other work. Among the threats are that GAI will be deployed to do traditional and current faculty work more quickly and inexpensively than faculty can perform it, but with substantial loss of value to faculty, students, and the quality of resulting educational experience, research, and other work. We're justifiably concerned at the prospect of cost and time savings will too readily lure decision makers into devaluing the contribution of live faculty deploying actual intelligence, genuine experience, and practiced judgment that they bring to the university's educational and research missions and to the attendant managerial activities such as assessment of students, faculty, staff, and administrators required to sustain them. We believe it's literally of vital importance to ensure that the distinctive and essential contributions to the educational and research mission of the university made by highly skilled, trained, experienced, live, face-to-face, eye contact enabled, collaborative, interactive, deliberative, and contemplative human beings be preserved and protected. It's clear that decisions around the use and management of GAI can make substantial difference to practically every aspect of our in-unit faculty members' working lives, including but not limited to assignments, rights to own and control work product, instructional methods, including the right and ability to refrain from using instructional technology, modes and methods of evaluation, and more. In light of these facts, UFF-USF chapter seeks to reach an understanding with the university to establish a trilateral committee with a membership composed of appointees of the university administration, faculty senate, and UFF-USF chapter to formulate recommendations concerning the use of GAI at the university and to report those recommendations to the presidents of those bodies. We're aware there are a number of existing entities at the university that are charged in one way or another with developing practices and policies involving GAI. These currently include the Center for Innovative Teaching and Learning and the Faculty Senate Council on Technology for Research and Instruction. We expect considerable further influence on these matters to emanate from the proposed new College of Artificial Intelligence and Cybersecurity. However, these bodies operate in relative isolation from one another, and none is specifically devoted to the task of ensuring that the use of GAI at the university is consistent with the interests of both the university's mission and the interests of faculty as employees with collective bargaining rights represented by the UFF USF chapter, with specific rights and duties established and protected by the CBA. Our aim is to make sure that the perspective of faculty as employees with mandatory bargaining rights be represented in the process by which policy at USF concerning GAI is developed. The Memorandum of Understanding we present provides a brief rationale for its proposals, offers a definition of general artificial intelligence, provides for the establishment of a GAI policy committee, articulates the considerations that committee is to address, the committee's relations with other bodies formally responsible for GAI policy, and its meeting and reporting duties. It further establishes university commitments concerning continuous learning and development for faculty in GAI technologies and related matters, as well as a right collectively to audit GAI systems at the university for compliance with agreed upon standards and practices, and a right to bring alleged violations of the memorandum to the GAI Policy Committee for expedited resolution. We are certain the USF Board of Trustees recognizes the importance of exercising the highest care in exploiting and deploying this volatile and potent technology. And we hope that, in recognition of our mutual commitment to shared governance, you will find this memorandum of understanding to be agreeable.
All right, thank you, Richard. Does anybody off the top have any questions about this? I know it's something we're probably going to have to take some time with and consider and digest, but
So on the membership, no student membership is your proposal?
We did not propose student membership.
No, so you don't, that was an explicit choice you made.
I don't recall that there was discussion of that at our meetings, but
This is a starting point.
Okay.
yeah,
No, I'm just, these are
Yeah, yeah.
questions.
Yeah, yeah.
And then on the audit, since you want the USF to allocate funds, are you asking for an external audit or would you want an internal audit office to conduct it?
Again, this is a starting point.
that's
So
some,
I'm asking
to
for
be-
what.
that's something to be discussed.
what your-
Give us the fors and against and what it would take to achieve the objectives, which is we want to get in front of what's going on. Warren Buffett the other day on Saturday said that he compared artificial intelligence development where we are today, where we were with nuclear energy in about 1940. And that if we don't get in front of this, we're going to be trying to wrangle it back into the bottle, if you will. I don't know if you guys follow NVIDIA, but Jensen Huang says that their new chip that's going to be coming out, which they've already developed, their manufacturing, is 4,000 times faster than anything that they have right now. And so this technology is just explosive.
anything else, Ed, for us today?
No.
All right, well, why don't we take a caucus? I don't think we'll be very long. Are you gonna stay here? We'll go. Thank you for that time. We're good with, most of this. We can TA, we can go along with and approve Article 4 and Article 5. It's not a problem. There's some changes that might need to be made to particularly 1 and 3. So we're gonna take 1, 2, and 3 back and get back to you on those. We just noticed that, for example, but I'm not telling you the universe of things we might look at, but there's a couple references in 1.2B to the Administrative Procedures Act. And that really doesn't apply to the state university system. It's a bog rag. So there's some things that we want to look at and be careful about and maybe make some suggested changes.
Okay, you gonna make those suggestions today? Or?
I don't think today, but like I said, I don't think we're gonna have any problem reaching agreement on those. We appreciate the remarks on the memorandum of understanding. We're obviously gonna have to take this document back and look at it carefully. And some questions were raised. We're be considering those questions and from our perspective. And we'll get back to you with a response. And I think that's what we have today,
You have no proposals?
not today. I don't know if there's any other business you want to take care of today.
Is there any bookkeeping sort of housekeeping considerations to raise?
Next meeting would be May 5th.
We're on the 31st, 2:00,
1:00.
1:00.
Oh, okay.
Yeah,
May
today
31st.
had to get moved back, was it? I
Okay,
had a conflict.
So you can do 1:00
I could do 1:00,
and it'll be you?
or my AI, one of the.
That would be Jason? Okay,
it's gonna probably be here, right?
Yeah.
It will be here. Okay, yeah, 1:00.
Whatever you want to do. Steve.
We should set some future meetings into June, do you think?
we can.
Okay,
We can have suggested dates if you want to do that.
Fridays work for you.
Yeah.
Well, that's right.
We'll communicate and
Yes.
suggest, and you can check with him because,
I'm pretty wide open in June.
are you?
Yeah.
Oh,
You know, this was a busy 2 days because a lot of faculty were going away from a lot of the universities, so
yeah.
there was business to be tied up in places.
Okay.
But I think in June I'll be much more open.
thank you. Okay, I guess we're adjourned for today. You
Yeah,
too.
it's been a while.
I would suggest that we start out introducing each other. Okay, I'm the chair, so I guess it's up to me. I'm Dr. Karen Brownsberger. Besides being faculty, full professor of entrepreneurship and innovation, I'm also the bargaining chair for the UFF USF chapter.
I'm Susan Ariev. I'm University Librarian for the USF Tampa Library, and I'm the liaison for education, psychology, and philosophy.
Debbie Sinclair, Associate Professor in the College of Business.
Tim Boaz, Associate Professor Emeritus, College of Media and Community Sciences.
For about 15 years.
And Sonia Ramirez, one I'm instructor.
In College of Education. I deal with organizational concepts. Greg.
I am Gregory McComb, and I am pushing the buttons on this machine.
Their secretary. Well, I guess I'll start at Michael Vanderborn. I'm with the law firm of Allen Norton and Burt, and I'm a regular employee.
I'm Stephen Tauber. I'm a professor of political science and am currently serving as the vice provost for faculty administration.
Angie Slanka, Chief Administrative and HR Officer for USF.
Chris Garvin, Dean and Professor of Art and Design, College of the Arts.
I'm Gerard Solis, and I'm General Counsel for the university.
Craig
And
is
is Craig online?
Yeah,
Yes.
Okay.
I'm on, I'm back there, quickly to hear me, Craig Dawson, Senior Associate General Counsel in the General Counsel's Office.
Well, welcome, everybody. Good afternoon. I don't mean to jump out if you have something that you'd like to bring up right off the bat, but we have some proposed changes in contract language. And we can share that with you and go through it and entertain the questions you might have. Unless you want to do something else.
No, I'm.
Okay, rarely do people leave it up to me. I'll take that opportunity. Tell your wife, she never leaves anything up to me.
Oh, good place on the draft.
We need more. There should be plenty there. There's also a clean version. If you're interested.
All right, everybody's got a copy. I just want to say, like preliminarily, that it may look like there's a lot of changes in the contract, but actually, a lot of what we're proposing are housekeeping changes. There's a few changes that are necessitated by law, because there's been some changes in Florida law as it relates to labor relations. So, if you're ready, we can go through this. Oh, we're ready. Okay, good. As you know, let's start at Article 1. As you know, there's been some changes in the law in terms of how organizations, employee organizations are certified. So they cover that waterfront. We added language at Article 1, Section 1, that certification number of 1395 might change in the future. You see where that is. Okay. We just think that would, pass the deck, so if it does change, it would still be good, right? Good. We, have down at section A under, one point, well, it's Board of Trustees meetings. We're striking that language at A about having a dedicated place on the agenda of board meetings. Still have the opportunity to speak in public comment. So that if something has to be brought to the attention of the board, if you have that opportunity, so we don't think that it needs to be a dedicated spot. Okay.
What page of the time say they are made available? On this one, the new one, the red thing.
Supporting material.
Minutes. Supporting materials and minutes. The same day.
No.
Same day. Okay, get rid of the second same.
It should be at the same time.
Right. Same
Yeah,
time,
same.
Got it.
That's pre-existing.
Oh, well, she'll change it.
Yeah. Yes. All right, moving on to Article 3. We are realizing that email is the form of communications most effective. And so we're allowing email communications to suffice. Well, I guess we can move forward to the discrimination article, which is Article 6. In the packet that you have, it will be on page 4, starting page 4. This is sort of a cleanup in one part. We all know that, sexual harassment and everything else that's contained in the statement of non-discrimination are all prohibited. There's kind of no reason to break that out and cite a Supreme Court case from 1986. Because sexual harassment is subsumed in the language of 6.2a, although there is a procedural change on page 4. The third page 4. When someone files a complaint of discrimination, what we're proposing here, what we think is the best course of action, is that complaint should be referred to under the non-discrimination policy to the EO office for their processing, because that's what they're doing, is to look at complaints of discrimination and do the initial investigation and the determination. So that's what we're attempting to do, right? Article 8 is a change at 8.4. This has to do with if there is a change in appointment, we are going to give written notice of the change of appointment. It used to be that the writing in the contract was that unless it was increased salary or promotion to a higher rank, it required acceptance of the item by the employee. When there are changes in appointment that we need to make from time to time that aren't subject to agreement.
Such as?
Well, let's say, for example, if somebody had in their appointment a special condition in employment, like a research line that became 1.3, and you change that in the letter.
But writing signifies that they understood the change.
Well, I think the operative language that's problematic is until agreed. Not that they acknowledge. On that same page, there's the summer appointments language in the collective bargaining agreement. We have a change there. Pretty much summer appointment is left alone, but we're simply adding what is our position as to how a summer appointment is driven. And it's those considerations that are laid out there. Achieving college department and CH targets, offering courses needed for students seeking to graduate as August, and budget. Article 9, when you're ready.
That's eight.
Yeah, sure.
Employees shall be offered this limit out first rights available supplemental summer instruction. So you're striking that out.
Yes.
So conceivably, the university could replace all of us as adjuncts.
Yep. So you can get a program with all of the veterans. And so, but it would save money.
Well, it's clearly our intent. And if you look at the language that we've left in, there is language on appointments being offered equitably as a qualified employees time frame for that. And even this language that's being struck has language in it that says it practicable.
Right.
So it's not a guarantee. If it doesn't work, it's not gonna happen.
But you can know, because in St. Pete's, one of the deans, one of the associate deans, in terms of making summer appointments, her goal was to save as much money as possible. And she hired people on that basis. So she tried to hire a number of adjuncts. So you should know that. Well, that's, what's good for the students. Hiring adjuncts is probably not what the students are going to need to graduate on. And that's what the emphasis is here.
Yeah, but also the SCH and the budget allocation, but about
The budget allocations and the budget allocations.
But in the summer, it always comes down when we decide to put in a bad job just to save money, even though they're not the best thing to do.
I just mentioned that it should be some of the historical occurrences.
Yeah, I appreciate it. And certainly this is negotiations.
Yes.
Yeah, we just.
Maybe something we could do with the language to come.
Yeah, because I mean, after all, we want to have something that actually won't be.
So it just, and I think that's an important point for all of us. But
Yeah.
I think that's always been the right of the university to assign in the summer. There's never been a guarantee that this available appointments would be offered to tenured faculty or tenure earning faculty and so on. There's certainly been a practice of that, and we're aligned in terms of there's a strong interest in that if it benefits students. But it's always been the case that the university can decide who to assign. That's a right we've had. That's not a change.
This language comes from memos that have been sent from me and my predecessors to chairs and deans about how to prioritize summer.
If anything, it gives it more, so it's not an arbitrary thing, that these are the goals that have to be met. No, I would say the fourth, well, it speaks for itself.
If you're ready, the next article or to change is Article 9, assignment of responsibilities. And this is really, we'll get to Appendix F, which is the processing of any dispute over the assignment. But the language in the current collective bargaining agreement that references arbitration and what an arbitrator may determine is now prohibited by the statute, because arbitration on personal matters of the assignments expressly prohibited by statute. We just reporting the law. That also is the case in Article 20, the grievance procedure from arbitration. With a lot of language struck and added to it. But what we really trying to do is just to comply to that. You're probably aware of that. Well, they would be glad.
I am part of the UOP, so yes.
Okay.
We're really quite aware of that.
Yeah. Okay, good. Article 23, salaries.
Oh, so you're not going page by page?
No, I mean, it's just generally what we're doing there is trying to fix it so that the statutory prohibition of arbitration is effectuated by the language of the Article 23 on salaries, if you're ready. What's going on here is a merit-based increase proposal. The university is proposing a pool of funds to each department for increases. That's one. Up to 3% of the August 7th, 2024 Indian salary base. Their eligibility is right below it. Continues to employ as ranked faculty, non-ranked faculty, within the administration employees from August 7th, 2024. Employed on the date the increase is paid. Have to receive a satisfactory above. New hires excluded from the pool, and you cannot be on a pit. Employees who are busy appointments, temporary appointments, or received a notice of non-reappointment or dismissal or resign with effective date current prior to the effective date of the merit-based salary increase.
You, just turning to grievances, you put in a step 3 in here. This is on page 4. This is,
Forget, correct, all pages are page 4.
yeah, this is, I believe,
Page 4.
He's here, I think this page 4.
well, I'm just wondering what are you planning for step 3 in the grievance?
Frank, do you mind if we stay on a salary increase? So what are the increases that you're offering?
3% of merit pool.
So what would that translate for each faculty member?
Hopefully, it would depend on, it would be 3% to, I suppose it would be,
I think
it's a pool that would be equal to 3%. And then if you meet the eligibility, you would receive it.
yeah, it's
Well, you noticed last time around, we had like 3% in the first year, 2% in the second year. Oh, this is only a 1-year contract?
Yeah.
Why?
Well, that's really proposing.
Oh, so you're proposing the 3% salary increase one time, and then we have to go back to the table next year for year 2 and 3?
right in terms of the available funding to build this particular proposal. Yeah, that's how it's set up. I don't think we're opposed to a multi-year contract, but we'd have to see if we could do the funding to pull that off. But we like multi-year contracts. We'd welcome a multi-year contract. We weren't sure if you had an appetite for that. And then we have to see if we can fund it. In the past, when we've done multi-year, we've always had the carve out that if there is a drop in anticipated funding, then the increase might not go forward. But if you're willing to do something like that, then I think that's something the university would be open to looking at again.
Yeah, because I've been communicating with the other bargaining chairs at the other state university. I mean, we are hoping to be one of the few that have a multi-year contract.
Yeah. And I don't want, and Mike, I don't want to get ahead of you.
No, go ahead.
So, but you know, we philosophically, we like multi-year contracts as well. Our approach here was more modest because the current contract doesn't have an increase for faculty in August. So we thought if we could agree to this, the faculty would get an increase in August without necessarily thinking that would be an easier agreement to get. And it was a 1-year agreement that gave money to the faculty. But if you want to look at a 3-year deal, then that's something we can explore.
And well, there was also something else, because we have been sending surveys to our faculty. The 3%, I don't think I'm going to be able to get that back. I mean, President Law told us that you got an increase of in recurring funds of $50 million.
Last year, 45.
Yeah. And against that, the 3% just scales, and I don't think we're gonna be able to do that.
Especially with inflation, every 7 years for 3.
Well, you're certainly free to count on proposal.
Let's go through this first.
Yes.
So if I may ask a question, reading redacted language is always a little challenging to move that. So the merit-based increase, this is like, it comes from the 3% pool, and then it's divided how among the recipients.
Based on the eligibility.
So, so the pool is divided by the number of eligible faculty members. Everybody gets the same dollar amount.
That would be across the board.
Across the board, if you have a satisfactory, I assume, is that what?
And not on a campaign, not just starting.
So you're not gonna come up with a formula like the people who got the 5 get more than the people who got the 4.
We didn't do that this year.
We didn't last time, no.
No, yeah.
So you're gonna develop an amount of money that's gonna be divided up based on what the pool of funds is, whether this is the in-unit employee salary base, not the the salary base of the eligible faculty for this. So it might be larger than 3% for each person, and it's going to be distributed equally as a percentage. Is that what you're saying?
Well, we don't know the numbers of how many people would be eligible for this if we would be ineligible. But
Right?
the,
Well, but
your point is
the number of
that
eligible has to be
3%,
smaller than the
Yeah, yeah.
number that are in the.
3% of the in-unit salary base is a number that could be,
Yeah, so it would be higher than 3% by some amount,
I guess it could.
but it will be distributed as a percentage rather than as some dollar figure. Right? I don't think it explicitly says that.
Yeah.
So.
This is the same distribution we did last time,
Mhm.
and I think that's how it worked. And
Right.
Okay. All right.
and I have clean versions of the agreements too, if you'd like.
Okay, it's just, I was wondering if I missed something here, but to me, it sounds like I didn't miss something. It's just not as explicit as I would think a contract would be. So.
The next article up is Article 25 in favor of deductions. Again, this is simply coming into compliance with the statutory language on public employers being prohibited from making any deductions from the paychecks of public employees. And that's already been in place since July 1st of last year, so we know what that is. We just trick up the number on Article 29, which is on page 5.
Oh,
Page 4.
We're moving to the next page. This is actually just one really long page. And it just changes the dates in 2016, 2019, 2021 to 2024. There's a few changes proposed for the appendices. I'm all the way to the back in the appendices. The next red line. This page, appendix D, and then appendix F. and, reform for the exclusive assignment dispute resolution. Are all changed to indicate the change in the agreements of the traffic. Do agree with the application of the law.
Does President Law have a sense of who the designee would be for step 3? Is that something that's been discussed?
I'm thinking like maybe a retired or, someone who had been an administrator, but was a survey.
I was just curious.
Can't use an arbitrator that doesn't exist, so I think that it's only like consistent with the law.
Well, some of the other universities are using, have actually agreed on using a mediator. FSU is talking about putting together a committee of senior faculty members,
Yeah, they're not gonna be,
you know.
the university's not gonna. They proposed, but the university rejected. I know there's a lot there, we read this. But like I said, a lot of it is, some of it's substantive. A lot of it's housekeeping. And a lot of it is mandated by changes to the law. We comply with.
So this is just not a matter of practicability. So step 1 and step 2 for the assignment dispute. I mean, we already have a president's representative, so we're going to have like 2 president representatives, and how is that going to be different? I mean, I just don't understand how you expect to come to a different outcome.
Well, it's not about the outcome, it's about the process.
Oh.
The process is, right now, with no arbitration against it, step 2, we're proposing that there be a right to appeal as step 2 or step 3. And then somebody who is not, so you decided to step 2, could be something to step 3.
But it's also going to be an administrator or a former administrator. So it's not going to be somebody who's going to decide the faculty or has experience.
Or is it for the study?
Sorry, Arthur?
It requires a bigger study.
Yeah, it does.
That's an understatement.
Could we have an electronic version of this?
Mhm. And to Tim's point, I have clean copies if you'd like clean copies.
Do any of you have questions, comments?
Yes.
Yes.
I think the 8.4 changes are problematic because I think the agreed to and accepted in writing by the employee protects employees from, constructive dismissal. And we want to do that.
How would that?
If somebody can change your appointment so it's arbitrary, and that language was in there before, arbitrary or capricious, and you have somebody who's trying to get someone to either retire or quit and make their life miserable by their assignment, that's called constructive dismissal, and it's not considered legal. And I do think this language asking the employee to accept that change in writing, other than, the salary rate or promotion, is good language to protect employees.
Well-
We do have people who make capricious assignments, who do try to push people out. We want to protect those people.
Yeah, well, this isn't assignment. This is a point.
Oh, I'm sorry.
Yeah, it's an point that I understand, but we also, and there's no ifs and buts about it. As a matter of fact, we had 8 people in the College of Public Health who just had their appointment changed. It was out their knowledge. They just went into gyms and they assigned a minute percentage to so-called director positions, and all of a sudden, these people were out of unit without even knowing it, and we don't agree to that.
We're not taking away the notice.
Yeah,
No,
they
but
got
I want
notice
people
before,
to
but they didn't
sign.
know, well, they didn't understand that notice. They didn't understand that that notice took them out of unit, didn't say that in the letter, and they never signed anything or discussed. They just got the letter,
Mhm.
And they didn't.
and they didn't
Agree to
understand
it.
what it really meant,
Or
or
didn't agree to it, so the green writing is absolutely necessary.
it was a 7% administrative appointment, and they told them, took them out of unit and changed their position.
And then they marched one of the people off campus.
And then they fired her.
Yeah.
Within 2 months.
Well, yeah, I can,
Yeah, I'm not familiar with that.
interesting.
Oh, you're not familiar with that?
I am, I know exactly what
I'm
you're
not.
talking about.
Okay.
Okay.
That's from this accusations of misconduct.
Oh, I see. Okay.
But, that was part of the
But,
problem.
But that is.
but you can still grieve all of those things you're talking about. We're not taking away that right.
It did take away the right to grieve, even.
Once you moved out of unit, but.
Without a written-
Well, she was moved out. Here
But anyone who
without
gets an
her-
administrative position by appendix A is out of.
7%. 10%.
It's on your administrative code determines what your.
And it was the same assignment she had at higher date.
Yeah.
And they just sent her a letter that she.
Administrators don't even have its finance.
Well, let me say this. If you, we could certainly talk about that, although I'd rather not get into an individual
Okay.
situation in public and it would be recorded, broadcast at that point.
But we do know that the
This happened.
situations help you to understand why we're concerned.
May I ask why you want to delete that language from 8.4?
Yeah, because there are times in which an appointment that needs to be changed. It's appropriate for it to change. And, you know, we, in those instances, want to be able to exercise that legitimate amendment of the appointment, that the appointment isn't something that's locked in for the life of that document.
If it's legitimate, why would there be a problem with the employee signing off on it?
Sometimes employees will not agree with that. It's something that needs to happen. I guess I gave you one example, which is an actual example. Someone was a lab, but they're not using it. You need the lab for another faculty member. But the lab is in their appointment.
Is the lab one of the items in 8.4?
Sometimes labs
Mhm.
or other kinds of special conditions are included in the appointment.
The appointments would be negotiated, if not. It would be, we don't have in the
We're not
beginning, it's why
negotiating.
then.
But it seems to me like an example such as that could easily be addressed in the appointment letter.
Yeah.
I mean, because you would anticipate, I mean, like, for example, if you have a lab as a part of the appointment, the facilities people decide to tear the building down, you're not gonna have a lab anymore.
Yeah,
I mean, you should, that's the sort of thing that should be anticipated in advance and dealt with in the appointment letter, and then you wouldn't need to address it by refusing to allow the faculty member the right to sign to agree.
We're getting everything that's gonna happen in your appointment letter.
I think a lab not being available in perpetuity would be something that would be pretty easy to anticipate.
But it's not, if it's torn down, that's one thing. It's, person's not using it and it needs to go to someone else who is using it.
And you don't think that we could come up with language and letters of offer to address those?
Yeah,
kinds of-
it should
well,
be. Without jeopardizing
Well,
rights.
with lab.
Yeah.
Well, the employee would have to agree to it.
So,
Yeah.
the other,
And
the
other
other.
thing
They
is
may
that-
say, I won't agree to that.
Well, let me just
Makes no
say,
sense.
first of all, to this, you know, if they're not going to agree to a letter that says, you know, this is subject to changing conditions, are you actually trying to deceive them as to what the terms of the letter, what the letter is.
No,
And
no,
I should point out, more to the point, there are 13 items in 8.3A, and you just referred to special conditions of employment. And you're striking everything out in order to get rid of that special condition because you don't want to rewrite the letter.
Well, no, I mean, the problem of, I guess what you're suggesting is that we reissue everyone's letter of appointment. That's, I think is unnecessary.
Not everyone's, just the ones that you're worried about.
Well, but they were having a, and you're basically asking for the same thing, I think.
Yeah, but you're asking us to weaken our faculty in order for this one person or two people who sit on lab space that they're not using. And I just don't see how benefit to the university is greater than the benefit that our faculty would be using under this.
Yeah, they can still, they're mistreated, they can still be bad.
Yeah, but how's that going?
Yeah.
What does that mean?
No, it's just, I just found out that FSU has 0 grievances and I'm sitting here on like 14, 15 this year alone. So this is just something that being the grievance chair and the bargaining chair, I have to be concerned about the grievances that come through my computer. And this is something that I can see abused by.
Well, it has been.
It has been.
They're not giving letters now, even though they're required to. Yes, they're not having signed.
Well, we could continue to talk about it, but an appointment letter should not be a lifetime locked in contract. This is your contract.
Appointment letters are issued at various times. Conditions when others change.
Yeah.
Not locked in forever, vice president, when there was 10 retirements.
That's all we're trying to recognize. So. Okay.
Thank you.
What was that?
Well, you most certainly gave us a lot to think about and discuss among ourselves. I would say that a bit now we're just on the table this and we have a lot of work to do. But I also would like to know the status of the MOU that we presented.
Yeah. The whole thing? Do you have a reason why you want to reject it?
We have several mechanisms to do with AI outside of the redundant that we
And that includes faculty rights and copyright issues?
faculty senate, we have CEDO, we have.
Most of the mechanisms in place are for adopting and adapting to the workplace, but not very many of them would address the issue of
We have a contract.
what?
A contract that if there's issues of employment, they should be handled in the contract.
Okay, so you want to wait to put AI into the contract and not get started on this?
Well, if you want, if there's something specific that you think should be in, then yes, but
Okay.
redundant, it doesn't seem like would be so.
Well, we didn't see it as redundant. We saw it as a committee that addressed faculty rights, which is not being addressed by a lot of the other entities on campus. There are a lot of faculty are concerned about their intellectual property, their course materials, and the misuse of AI in that aspect of things. And that's not really being addressed directly anywhere else.
You could bring it up back in the Senate.
Okay, whatever.
So then I have a question about Article 6. So you basically want to take all discrimination out of the CDA, except all discrimination due to union membership.
We want to have discrimination, workplace discrimination outside of discrimination retaliation under 447.2 to be processed under our existing policies and offices that are dedicated to that. Yes.
Similar to what I'm thinking about.
Yeah, but I saw that you struck out all the titles that we inserted to lack of.
So that reference of about or say it's part of the city.
Yeah.
It's okay. I can't make.
So then also under this language, we would not be allowed to brief, if we think that the Title IX office has violated faculty rights. Because right now I have experience that I find.
A grievance that is against the Title IX office, is that what you're saying?
Correct. Correct.
Because the Title IX office,
Well, not the Title IX office per se, it's what the supervisors of the faculty member.
you mean an employment action taken as a result. That can be agreed.
Yes, that's still agreeable.
Or disciplinary.
But I'm not quite sure I understand the reasoning for you taking out racial discrimination and any other discrimination except for due to union membership.
We're not, we're just having it. We're having it processed and considered. And if there's a remedy available, remedy by those people who are the designated experts in that area. These people who have been trained in doing investigations, these people who are aware of the law in this area.
With all due respect, I filed complaints with these offices before.
Okay.
I was not happy with things that didn't being handled. So as a faculty member, I have to say that I would really like somebody who's on my side to handle my complaints, other than people who work for and are paid for by the university and whose jobs depend.
Well, if you file a workplace discrimination claim, it would go to step 1 and step 2. And those will all be heard by university personnel.
Well, I went through it. I'm very well aware of it.
Yes.
But I'm also aware that the deans, in my case, had really overbearing impact on the proceedings. Because try accusing your dean of wrongdoing and then going through HR, and those people are afraid of deans. So how does that work out for the faculty? I can tell you exactly in my case how that worked out. The university wasted $30,000 in hiring a special investigator to have me investigated. And since I'm still here, that was wasted because I didn't do anything wrong. What I'm trying to say is that as a faculty member, you telling me that I have to turn to the university if I'm being discriminated against, to me as a faculty member, that really is not a viable path.
No, what we're saying is that instead of going to step 1 or step 2, which you could find that in the grievance article, that's internal, that's step levels of supervisors. You would take a discrimination claim, which has a body of law that is well-defined by courts and by statutes. And that those people who do that every day, who've studied it, who've been trained in this area, would be able to consider your complaint and bring about a remedy if there's a remedy. Why not have the experts consider it as opposed to a supervisor?
Because the experts, the way I've experienced them, and I'm not the only one, you can talk to any number of people who have gone through this process, do work for the university on the university's payroll, and they're rarely going to do anything that goes against the dean.
Well, I don't disagree.
Sorry, I mean, come on. Don't get me started.
No.
I'm retiring next year, and I got a letter from HR telling me that I'm retiring this year. So talking about expertise.
Okay, well, then we're saying is that your choices are step 1, step 2, or going through this office of people who are trained in this specific area. I think it's obvious that the latter is the better course of action.
Who do those people report to? The people who are trained?
Actually, the people that are doing discrimination complaints are given a lot of independence.
But who do they report to?
And some of the scenarios that Title IX works up their compliance and Title VII. Like if their Title IX would report through me, and this is newer, so I'm not sure about your past experiences. And then I report to the president. I'm not afraid to leave my dog.
Yeah, but you might not always be in your job. The contract holds us to a contract.
Yeah.
Also, if I was, correct me if I'm wrong, but I believe we talked about this last contract. And I thought one of the reasons for wanting the grievance process was so that the victim would have someone with them through the process as well.
Right.
Because you weren't allowed to take an advocate with you in this process.
Right.
I think we clarified that you can have a representative. I think we clarified that. I think the issue was that you guys had an older version of the policy.
And there have been Title IX cases where
Yeah.
we know for a fact that
Right, advocate.
the person
You
who
can
was
have-
accused or the person who was doing the accusing had an advocate there.
So
Yeah.
we can, anyone can bring an advocate.
You
whether
can still bring your
it's-
union
your
rep.
Union rep.
Yes.
Even, okay.
If you're accused being a member of it.
I don't like the power play.
Mhm.
I don't like the power play. So basically, we're giving faculty rights over to the administration. And then we are using offices that were established. And a lot of them, and no offense to you, are not very faculty friendly. They're just not, and I've been here since 2001, so I speak from experience. And since I'm grievance chair, I'm dealing with a lot of grievance, more so than any other university I just found out. So I just want faculty to be protected, and I just don't see how this is. I mean, personally, I would never file a Title II again. That's a waste of my time. There were due process violations galore, where I was being told that I had 1 hour to take notes while going through packages about this thick. I had 4 of them, and all I was allowed to take was 1 hour in handwritten notes. I was not allowed to photocopy anything. I was not allowed to take photographs of anything. I had 1 hour. And that was a violation of my due process rights. And it happened here at USF, and it happened with Title VII. And that's why I will have to talk to my faculty about it, because I'm basically a spokesperson as the chair of this committee. But this is just a very, very serious problem that I see with that.
Okay, well, I think we both have explained our respective positions.
Okay.
I have one comment. My impression of that one of the benefits of the grievance process is that it kept stuff out of court,
What?
that it keeps stuff out of court. Court is unpleasant, court costs money. You already know that from the amount of litigation currently going on. I think that one concern about further constricting the grievance process is that the overflow into the courts will increase.
I don't know if that's going to be the case or not, but, we're all subject to state law and, the law, has changed, and the law is, now, restricting, parts of the grievance process. It's not our initiative. It's wrong with that.
Is this part of the law?
Yeah, everything having to do with sexual harassment, that language that we struck on sexual harassment is so outdated. That comes from the blue book, from the Board of Regents. And there probably has been 10,000 harassment cases. I mean, it's a sexual harassment. Harassment can be in all sorts of forms of protecting class. It's so outdated. But anyway, that's why we struck that.
I don't see how it works. Is there a reason that you
Well,
wouldn't want?
it misses the point. The point is that we have now protections for all the classes that are identified in the contract. And it has to do with the law on retaliation, the law on harassment. It's not limited to sexual harassment, and the site is really not current law,
So
so.
can we get rid of can we update the law and not get rid of the grievance process?
Oh, well, that's a separate thing. You know, and we told you why we think that going through, the Title VII, Title IX processes that are established for that particular purpose makes better sense than going through step 1 and step 2.
But in this case, we have both options. We have both. Yours, we don't have an option. We don't have.
Well, we think that Title VII and Title IX offices and experts are trained and employed for this purpose, so. But we think
That's it,
it's
so they're
best practice.
by the university and they.
Well, not
Yeah,
all
but-
faculty have competence in that process, in those entities, in those
Yeah.
organizations.
The person who does step 1 and the person who step 2 are also employed at the university. That's not a distinction.
Title IX is,
Yeah, we know we were here.
you know, there is retaliation.
See, instead of weakening Article 6 as the grievance chair, I actually would have wished that it was going to be stronger. Because what always struck me as out of kilter is that Article 6 was pretty much focusing like over 90% on sexual harassment and didn't give a lot of reason for any type of other.
Right, like bullying and.
Yeah, and so instead of making it stronger, now we're taking a whole bunch of stuff out. And also what I use the grievance process for is a lot of times discovery. So I can get my grievance when I hook them up with lawyers, all the stuff that we have discovered. And if I'm going through Title VII, which I'm not the only one whose due process rights have been violated, I just don't see that happening. I mean, I was the one who was the accuser, and I didn't even get copies of what the people whom I accused answered to my accusations. I mean,
Same here.
Just one piece of this. I'm not familiar with this and I won't go into details, but this is very recent for me to be overseeing this area. Very recent, not less than 6 months. So, so maybe at some other time, you know, I'd love to hear a little bit more detail about your experiences. But previously there were separate entities on each campus, and now we've brought folks together so that there's an even experience with how people interact with our departments. And there are trained professionals with an entirely new structure supporting us. So I just, you know, in our process, I would just like not to blend the two situations together because I'm not familiar with them, but I'm happy to talk with you later.
Anything else?
not right now.
Okay.
We will have to mull it over.
Okay.
Not at this moment.
Okay. Does anybody want to take a caucus or we good?
And if they're finished, I don't know that we need to take a.
We're going to meet separately.
Yeah.
All right. All right. Thank you very much.
Thank you. Nice meeting you.